Hello and welcome back to another video. Today we will look at one of the most important cases in contract law, namely Currie versus Misa. This case is important because it gives us a landmark definition of consideration that is still used today. So let's get into it. First, the facts of the case. In 1874, two businessmen in Victorian England made a deal. One businessman, Mr. Currie, dealt in money. The other, Mr. Misa, dealt in securities. And the price of those securities was constantly fluctuating. Now, Misa owed Currie £600 for some securities he had bought from him. However, the amount of money owed, £600, was only payable in 3 months. At present, though, Misa wanted to pay off his debt. He asked Currie how much he would have to pay to settle his debt early. Currie told him that to make it worth his while, he would have to pay £100. That way, Currie would be giving up for £100 worth of interest. Deal struck. However, when all the paperwork was ready to be signed, Currie refused to go through with it. He said that there was no consideration for his promise. In other words, the agreement wasn't legally binding because there was nothing of legal value exchanged between the parties. Did Currie have to pay the £200? Well, to answer that question, we must examine the judgment. The court laid down a famous definition of consideration. It held that consideration may consist either in some right, interest, profit, or benefit accruing to one party, or in some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other. In simpler terms, consideration is the exchange of value, whether benefit to one party or detriment to the other. Now, if this sounds confusing, let me break it down. The basic idea of consideration is that if I want to enforce a promise in court, I must show that I gave something of value in exchange for that promise. In other words, I must show that there was an exchange of value. But what exactly does this mean? Well, this can take many forms. For example, if Mr. A promises to give Mr. B $100 and Mr. B accepts, then there is an exchange of value. Mr. A is giving $100 and Mr. B is promising to accept it. The same is true if Mr. A promises to do something for Mr. B, in return for Mr. B promising to pay $100, even if it doesn't complete his side of the bargain. The fact that he promised to do something is enough for consideration. This is because a promise to do something is a benefit to Mr. B, who can sue Mr. A for breach of contract if he doesn't perform his side of the bargain. Let us apply this to the facts. Here, Misa says that he had already paid £390 of the £600 debt, and so it would be a benefit to Currie if he accepted the £200 bill, because then he would be getting £400 of interest. Currie argued that this was not good enough. He wanted to show that there was fresh consideration for his promise. In other words, he wanted to show that there was some other benefit or detriment that accrued to him at the moment that they agreed to the £200, but there was none. The judge reasoned that the only thing that happened after they agreed to the £200 was that they drew and accepted bills of exchange. But drawing and accepting bills of exchange is merely a method of discharging a pre-existing obligation. It does not create fresh consideration unless there is a new promise or undertaking which induces the other party to alter his position. Since there was no such evidence, the court ruled in favor of Misa. This means that even though Currie had first offered to forgive the remaining £600, he was not allowed to go back on his word because there was no valid consideration for his promise. In other words, even though the deal looked unfair, the court could not enforce it because the law of contracts requires a bargained exchange of value. In conclusion, Currie v. Misa is a landmark case in contract law because it gives us the leading definition of consideration. For a promise to be legally binding, there must be consideration, which is to say there must be some exchange of value. This can take the form of a benefit to the promiser or a detriment to the promisee. But in this case, neither existed, and so the agreement was never legally binding. If you found this breakdown of Currie versus Misa helpful, make sure to like this video, share it with your classmates, and subscribe for more simple explanations of contract and tort cases. Leave a comment on which case you want explained next, and I will cover it for you. Thank you and see you next time.